Give me liberty and give me Annette.
Welcome to Annette on Life, Liberty, and Happiness. I'm Annette Bybee, I'm your host, and I'm joined today by DK Williams. Hello, DK.
Hello, Annette. Always a pleasure.
Yes, and I have invited DK today because he is my resident Constitution expert, Supreme Court decision expert. And before we get into the subject matter, tell us where we can find you, DK.
Yeah, thank you very much. I do a podcast on legal issues, deal with a lot of Supreme Court cases. Early on, I did a lot of historical Supreme Court cases. Still do some of those, but also do a lot that are like current and in the news right now, much like the one we're about to talk about. And you can find those podcasts. Probably the easiest thing to do is follow me on Twitter, or just go to the Twitter page and you'll see the link, and you'll get tweets whenever there is a new podcast coming out. And I will have one on this case that we'll discuss. And the Twitter handle is @thelawdkw. So go check that out. Also on Facebook, if you prefer that medium. It's there's a Facebook page for The Law with DK Williams. Check them out. Thanks.
Awesome. And I will include that information in my show notes for those of you that are driving and didn't have a chance to write that down. DK has a good talent of being able to take some of these legal issues and simplify them a little bit and explain them in a way that's easy to understand and interesting at the same time, which is why I keep bringing him back.
Thank you.
You're welcome. So we had a big case come down on the 25th of November, and today's December 3rd. And, on the face of it, it's good for those of us that are liberty-minded and are constitutionally minded. There are also a few things that are concerning about it. For example, that was a 5-4 decision. It was awfully close for a decision which should have been really a 9-0 in a perfect world, for at least a 6-3. But the fact that it was a 5-4 is a little concerning to me. But why don't you tell us what this was about?
Yeah, absolutely. And I think some history just from the past, since this past zombie apocalypse, right, when things started to shut down. The Supreme Court dealt with two cases like this already that are similar to this. And what happened here in this case was Andrew Cuomo, governor of New York, had this scheme, or this outline or plan to color code different parts of the state. And depending on what color you were in, they would have different COVID restrictions. And he had some COVID restrictions for a particular category, which two churches fell into: the Archdiocese of Brooklyn, not Arch, it's the Roman Catholic Diocese of Brooklyn, and a group of Jewish synagogues.
Right.
So they were affected by these rules, these regulations, because they had been just put into one of the categories. And that's part of this case, is that the governor can just put you in whatever category he wants, whatever he thinks is appropriate, right?
Really arbitrary.
And there's been a couple of times where churches have just been moved around, and that became an issue, or it is an issue in this particular case. But the particular restrictions on churches that were in effect at this higher level of emergency color, right, limited them to 25 people, I believe, if that's the right number, per, or no more than 25 people could be in the building, right? And some of these churches seat, 750 or whatever. They seat a lot.
Right.
And the rules were different for other secular places where people meet, like substantially different, like stores and liquor stores. Of course, churches always bring that up. You can have more people in a liquor store than you can in our church, right?
Yep.
And in a church, especially one that's big, it's easy to social distance. And
Yeah.
there was never any allegations that either of these churches or these group of churches were like violating the rules. It was just that we only want a certain number of people to be able to attend.
And there was no evidence that anyone had gotten COVID from attending any of these churches.
Right, exactly. And the churches sued on First Amendment grounds, and that's an issue. Let's save that for a second. This whole incorporation issue of the Bill of Rights. So put a pin in that. And the churches said this was a violation of their right to practice their religion the way they want to, right to assembly. I mean, there's lots of things in there that this was a violation of, and not just because it limited them, which I think would be enough, but it treated them significantly differently than it did some secular groups or places where people meet.
Right.
And this ruling is actually, it's not a final ruling on the merits. It was for a temporary injunction, which the idea behind that is, hey, here's these rules. We can sue and have the long out. We can have the hearing, but that in the discovery process, and you go through all of those hoops, and that takes a long time. But meanwhile, we are suffering damage while this is still in place. So the temporary restraining order, if you seek one, says pending that final resolution, after we go through all the discovery and we go through everything, if we have a trial perhaps, they very well could have had a trial, and they still might. Pending all of that, we're being restricted from worshiping the way we want to worship. It's an ongoing harm, and therefore we want this temporary order. So those get dealt with quicker. And one of the things you have to show to get one is that you have a good chance of winning eventually. Because if the judge is like, you got no chance of winning, I'm not going to grant this. So you have to show at least some evidence that you've got a good chance of winning after it's all said and done, that you're suffering harm and that it's ongoing and immediate, basically.
Right. And for churches, obviously, we're talking about every week. Every week
or more.
You cannot attend church or synagogue, you're being irreparably harmed. And that was one of the things they said in there, was that with First Amendment rights, irreparable harm can happen instantly.
Right.
Every week that I can't go to church, I'm irreparably harmed.
Yep. Right. Exactly. And that was the reason, or one of the reasons, that the Supreme Court in the 5-4 decision ultimately granted the temporary restraining order, which had been denied by the federal trial judge and the Court of Appeals. So U.S. Supreme Court's one that granted it. So that's kind of the procedural setup for it, the background.
So if this is just an injunction against Cuomo in this case, so it has no broader application outside of that, right?
Right. Plaintiffs or lawyers will look at this and the majority decision, and they'll say, hey, the court said here X, Y, and Z. And while our facts are different, facts are always going to be at least a little bit different. This legal standard that they pronounced applies here. So that's how judges will do that, or lawyers will do that, and justices will do the same thing, because it happens here. Because those two earlier cases where they dealt with different rules in different places, but they denied injunctions. And I think we talked about one of those not too long ago. And I did a podcast on a case from 1903 or whatever that was, over 100 years ago, Jacobson versus Massachusetts, where the town of Cambridge said, if you don't get a polio vaccine, we're going to fine you $5. Guy didn't want to do it, went all the way up to U.S. Supreme Court. And in that case, U.S. Supreme Court said, yeah, the city can do that. And there's some scary language in that opinion, which I discussed in the podcast. So you can go check that one out. It was Jacobson. And the reason I did that one, because it was spurned by one of these started by one of the case from a couple months ago, where the Supreme Court denied California churches attempt to do the same thing against the California rules. And I think it's very obvious to anybody paying attention to it that the real difference between that case and this New York case, the facts are different, absolutely, rules are different standards, but the real difference is
we have a new justice on the court.
Yes, exactly.
I know, and that's what I was waiting for. Remember when we talked about that case, and I predicted that she would be put on, and that she would be put on before Trump left office, and thank goodness that happened. Although we still have the specter of the possibility of court packing. I'm guessing it won't go on because the Senate's going to be too close. Even if those 2 seats in Georgia go Democrat, you're still not going to have enough Democrats, I don't think, willing to say, let's pack the court, because that's a huge, huge change.
Right.
And I don't see that happening. So
and it could come back to bite them in 4 years.
Yeah, exactly. So I don't see that happening. So I'm thinking it's a good thing. And having the new what are we calling her? Are we going with the notorious?
Oh, ACB works for me. Anybody with 3 initials works.
So I was thrilled to see that. But the fact that it was 5-4, and only after she came on the court.
Amy Coney Barrett replaced Ruth Bader Ginsburg. They both have initials. So ACB replaced RBG.
Yeah.
That's the real difference here.
Right. Oh, yes.
Yeah. And so we talked about just how lawyers will argue that even though this is a different fact situation, this legal principle applies. And that's like, and if you don't think it applies, you say, well, yeah, that case was different. So that legal standard, that legal conclusion that the justices came up with doesn't apply to my case. And that's called distinguishing the cases.
Right.
And the justices do that all the time. And they do it here about those earlier cases. And they basically say, oh yeah, these rules are so different. That one doesn't apply here. And they do that. And of course, you know, they don't make any mention of footnote. Yeah, but that case had RBG and this one's got ACB. You know, they don't do that.
No,
They
of course,
just have
we
to
all know that.
pretend it's a monolithic entity. And the reason they're not following those rules that they set up then is because it's a completely different set of circumstances. Whether or not it really is.
Yeah, I know the facts were different, but it's not that different.
Right.
I mean,
right,
what Cuomo is doing in New York is not that different from what's going on in the other states that are, I mean, it's the same things going on here. Oh, now we are in the red here. And so I feel for these churches because my church keeps having to change the rules. You know, we were at a point where we were going to go every other week because we were allowed, I think, 50% capacity when we were in the orange or yellow, or wherever we were at color.
Right.
And then all of a sudden, oh no, you're red now. So another email goes out literally a week after the first email saying, sorry, now you're going to only go once every third week.
Right.
So I've basically gone from twice a month to maybe once a month, maybe twice a month occasionally. And like they said, you know, there are things that you can't do virtually in church, like receiving what Catholics call communion, what we call sacrament. You can't do that virtually.
Right.
So I'm irreparably harmed every week that I can't go to church.
Right. Yeah.
And so I feel the pain of these people. So that, you know, leads me to the question of if someone in Colorado was to bring the same kind of a suit, does this ruling signify that the court will at some point hear a full-on appeal and rule this way that will have a broad application to other governors, or how does that work?
You know, again, it's going to go back to that distinguishing the different rules. I mean, if a justice or a judge says that the rules we're talking about on whatever case it might be, Colorado, if a case came up there or here where we both are, a judge could say, yeah, this is close enough to what the U.S. Supreme Court did in this I keep saying arch. I don't know why I say arch. I'm totally not Catholic. The diocese of the Brooklyn, the Catholic Diocese of Brooklyn. That's what it is versus Cuomo. If the rules that were applied there are close enough to here in Colorado, they can apply the same rules. But if they say, no, it's different, we're going to apply the rule, how the result that they came out with like 3 months ago or whatever it was. So that shows you the enormous power that judges have. They get to decide
the ACB, that. I'm just guessing with ACB on the court now that in a situation similar, I mean, the facts may be a little bit different. Maybe Cuomo's exercising his power a little more arbitrarily. I don't know what our governor Polis is going by, if it's number of cases put us in the red or whatever. But you're still being, your First Amendment rights are still being severely restricted. So I don't know whether, you know, how that compares. And I still know that I can go to Target with no problem with a ton more than 25 people. I go to church and it's like we're all, you know, completely social distanced, masked up, the whole 9 yards. And you go to Target and I can walk right by people. That's not
right.
So,
exactly. And one of the things the dissent brings up, and just to, you know, talk a little bit about their opinion their results, is that in a church normally there's more conversing or singing, right? People recite stuff, they sing, and some of the justices that were on the minority side of this, the dissenting side, were like, you don't do that anywhere else. So that's why it makes sense to have these rules only in that only apply to houses of worship and not to the Target, because you're not reciting long things next to people or singing a lot. You know, that's one of the things they pointed out. That's one of the ways they tried. And they also pointed out, the dissent pointed out that there were some secular groups or organizations or commercial opportunities that were treated worse than the churches here. And they're saying, therefore, they're not picking on churches, because here are some examples of things that are completely closed, like the theaters in New York, right? Like the Broadway theaters. And some people put a lot of stock in that, but the majority was like, it doesn't matter that some other people are being treated worse. What matters is compare how the churches are being treated to another group of people that are being treated better. And there's a list, like a 3-part checklist that the justices go through to determine if those differences are warranted or warrant a grant of the temporary injunction.
Right.
So yeah, there's a whole lot of applying facts to the law. The case law has been around since the Constitution, basically, and applying the facts to that. And there's a whole lot of discretion involved. Now, I think most of them are honest. I mean, I disagree with them a lot of times, but I think they are applying what they think the law is. And sometimes they're just obviously wrong, right?
Right. Well, one of the interesting elements to this case, of this situation, is that Cuomo is being accused of basically disfavoring religion. He doesn't like religion.
Right.
And we keep hearing stories after stories of him coming after Jews for holding
Right.
weapons. And it's like,
Yeah.
obviously this man has some animus toward religion. And what's interesting is that I love Gorsuch. Gorsuch has some good lines in his.
Very good.
He says, "Who knew public health would so perfectly align with secular convenience?"
Right.
Right. You know, because he says, at least according to the governor, it may be unsafe to go to church, but it's always fine to pick up another bottle of wine, shop for a new bike, or spend the afternoon exploring your distal points and meridians. I don't know what that means, but a bike thing?
I looked that up.
What does it mean?
That has to do with chiropractic.
Oh,
yeah.
There you go.
Right.
All right.
Where they're going to put the needles or pressure, I guess.
Right. But the other thing he says that I just, I'm proud of Gorsuch right now on this case. We might be mad at him for another case, but I liked him on this case. And later on, he says, the only explanation for treating religious places differently seems to be a judgment that what happens there just isn't as essential as what happens in secular spaces. Indeed, the governor is remarkably frank about this. In his judgment, laundry and liquor, travel and tools are essential, while traditional religious exercises are not. That is exactly the kind of discrimination the First Amendment forbids.
Yeah, right.
I thought that was great because, obviously, if you're not a religious person and maybe you're not a big First Amendment fan, then you think, well, why is it important people go to church? That's nothing. That doesn't matter at all.
Right.
And but people have got to go and take care of their distal points or whatever.
Yeah, right.
They got to go to their chiropractor. They got to go pick up a bottle of wine. And I like the fact that that is exactly the kind of discrimination the First Amendment forbids. You like it or not, the free exercise clause exists in the First Amendment, and the First Amendment is part of the Constitution, which is the bedrock law of the land.
Yeah.
So,
and 2 quick points on that. People get to make their own decisions. I mean, so you might think it's really stupid to go to church. Okay, you can think that, but that doesn't mean the state can prohibit people from going to church.
Right.
And that's what this is about.
Yes.
And anything, you might think it's stupid to believe whatever, but that's completely different than the state punishing people for believing it or acting on that belief.
Right.
So, I mean, America's filled with people that think other people are doing something stupid, but they get to, right? I mean, that's fine. As long as they're not hurting other people, right?
Right.
And then I know then that's where this goes. Then it goes to, if you get this disease and you spread it, you're hurting other people. Well, there's really no end to that, because if you get too fat, then somebody else is going to end up paying for your medical bills. It's going to drive the cost up, with Medicare and everything else. So there's no end to that.
No.
And you have to look at the totality of the circumstances. And I think one good thing about this opinion was that it did not directly say Jacobson versus Massachusetts was no longer good law, but Gorsuch, what we're reading from Gorsuch is he had a concurring opinion. So he took that one to the woodshed. He said that is not applicable to basically anything anymore. He doesn't say it was wrongly decided. He says it's no longer applicable to anything, right? So kind of the same result, but he doesn't have to call for overturning it. And another line that he said in his concurrence was, there is no world in which the Constitution tolerates color-coded executive edicts that reopen liquor stores and bike shops, but shutter churches, synagogues, and mosques. So, I mean, that's makes perfect sense to me. I think that's correct. Now, we put a thumbtack in this idea of incorporation, right? Because you mentioned the First Amendment, and this violates, that's what the argument is, it violates the First Amendment. Well, the First Amendment by itself has zero application to states, zero. And I know this has come up before, but a lot of people don't get the history of this, that when the Constitution was created and the Bill of Rights was adopted shortly thereafter, the Bill of Rights by its own terms, I mean, go back and look at it. I mean, I'm such a huge proponent of like, if you're really interested in this case, don't listen to us, go read it. So I'm a huge proponent of people reading what they're talking about, because when people have strong opinions about something they haven't read, you're wasting everyone's time. Just read it. If you want to say, I haven't read it, but I heard this, okay, you're being honest about that, which is good, because far too many people on the news or the radio, whatever, have this incredibly strong opinion, and it's clear from listening to them they haven't read it because they say stuff wrong about what the case says. All right, so back to the First Amendment. The First Amendment and the rest of the Bill of Rights applies to Congress only, to the federal government only. So at the time, Massachusetts or New York, any of the original 13 colonies, or up until the 14th Amendment was passed, any state could violate the restrictions on the federal government in the Bill of Rights. So it had when they passed it, the drafters and the people that voted for it weren't worried about their states. Like, hey, we'll deal with our states. They were worried about what the federal government could do. Right. And so, First Amendment, Congress shall make no law. Okay, that has no application to the state of New York or any other state or municipality or whatever. Only the federal government. A lot of people don't get that, right? Just because they've never been taught it or looked at it or worried about it or dealt with it. It was the 14th Amendment after the Civil War where states and localities, governments were, by a state action, not allowing freed slaves or just people of color, black people, even if they weren't slaves, they weren't allowing them to do what citizens are supposed to be able to do, like vote, for example, or run for office. I mean, there were times when, the Ku Klux Klan was largely a function of the state in some places, like the sheriff would be in the Ku Klux Klan or the mayor or whatever, right? And, I'm reading this biography of U.S. Grant, and we're in Reconstruction now. We're kind of talking a lot about that. And the federal government was trying to get some of these areas to treat the freed slaves like regular, real citizens, because they're free. They are now they are citizens. And they knew that the First Amendment or the Bill of Rights didn't apply to them, right? Because that only applies to Congress. Well, the 14th Amendment is the first amendment that says states shall not, or no state shall, right? It is telling states what they cannot do. First one. And up to then, the Constitution had no restrictions on states except for things like only the federal government can print money. I mean, that's in there, right? Bankruptcy laws, that's in there. But it was more about the structure of what the two different levels of sovereignty, the state and the federal sovereignty, what their responsibilities and powers were. So the 14th Amendment says no state shall deprive, the three main things, must grant equal protection of the laws. So you can't have one group not allowed to vote, or you can't go beat up those people because they're voting. You must give everybody the same privileges and immunities of being a citizen. And it makes clear that if you're a citizen of a state, you're a citizen of the United States. Because some people, there were arguments about that. And no life, liberty, or property can be deprived without due process of law. So, and they say states can't do that. Right. And, what does that actually mean, right? And it doesn't say, the 14th Amendment does not say the Bill of Rights now applies to the states. It doesn't say that expressly, but that's what the court has done over 150 years or however long it's been. And it's funny, funny, unusual, or something, that they did this on a case-by-case basis. So the First Amendment, and it's broken down into parts too, right? Religion, assembly, press, all that. And so when an issue came up, the Supreme Court would say, should we incorporate this restriction on the federal government to the states? And they almost always did. Or they have now. There were some back and forth for a while. But now basically every prohibition on government action that only applied to the federal government now also applies to the states. So that's this idea of incorporation. That the Bill of Rights was incorporated to apply to the states by the 14th Amendment. Now, a lot of people think that's bad analysis, but that's another issue on it. But you could get to the same result, in my opinion, without relying on incorporation. Just look right at the terms of the 14th Amendment, which says no state shall deprive anyone of life, liberty, and property. Well, if you're telling somebody they can't go worship, you're denying them that right that they have to get together and worship. And the 14th Amendment says no state shall do that. So I think you can get there without incorporation, but that's how they do it now. They do it by incorporation. So there you go. That's my long-winded thing on incorporation.
If the governors could violate our rights, it really wouldn't matter whether the Fed is doing it or not. So it's a good thing that we can hold them responsible the same way we would the federal government.
Well, just to be devil's advocate, the idea would be, well, the people of the state should do that. If the people of the state don't want the state government treading on your rights to assemble,
well, don't most states have constitutions?
Do it.
Don't most states have constitutions with, similar?
Yeah, most states do. Yeah, most state constitutions are based on the federal constitution. Most of them, at least since the original 13, because they had state.
When you have a governor who's ignoring it completely.
You've got state courts. I mean, and see, because that is a double-edged sword, because what if a state wants to do something that you don't want them to do, right? Or, so it's, if you want them to do it, great. If you don't want them to do it, not great.
Yeah.
Right. But that's what the democracy part of this country, you vote on people to go do things. You vote on the governor and the legislature. In some states you vote on judges, but not in Colorado. You vote for those people, and they get discretion. And so the fact that the federal government, the federal constitution now applies to these states, and it has over the past 100 and something years. Actually, it was the Second Amendment was one of the last ones incorporated. Did a podcast on that one too, DC versus Heller, where it said the First Amendment applies to individuals.
You mean the Second
And
Amendment?
the states can't deprive you of it, of the right to keep and bear arms. So, it's the big government, sets the rules. It applies to everybody. I am kind of partial to letting the states have a lot more. It doesn't have their original authority and their original powers, and which have largely been taken away. Not just, the Bill of Rights is a minor point, because I think most states would apply the same ideas. Now, they would do it differently, absolutely. But the real big problem was when the federal courts, the U.S. Supreme Court, started applying the Constitution to anything the federal government does that affects interstate commerce. That's what really sucked all the power from the states and gave it to the federal government. And I think that part of it is completely illegitimate.
I did an episode about a month ago, maybe a month and a half ago, on and my listeners that haven't listened to it, go back and watch it. Basically, I was advocating Article 5 convention,
right?
And one of the amendments was about putting the interstate commerce back where it's supposed to be,
right?
And basically, it was all about pushing the power back down to the states,
right?
In any way that you can. So, it doesn't show a lot of chance right now, but a lot of us are going to keep working at it, because I don't see any other solutions, real obvious solutions at this point. So.
I think nullification, if states just refuse to do what the federal government tells them to do when there is no legitimate constitutional authority for it. And that's what states did for a long time. It's rare. It's not going to happen that often, but when it does, when there's an issue that is so important, it's, I think, a duty to not comply with it. And I think you get a lot more success with individual states doing that. I mean, heck, Article 5, go for it, right? But what you're going to do, even if it's successful, is you're going to have some words that say something. Well, we have those words now.
Yeah.
They're just ignored,
Yeah.
right?
Yeah.
So.
Oh, you're right. We do have words, and they are ignored.
Right.
And that's one of the big issues with, with all the COVID restrictions, lockdowns, everything, is we just need to see people refusing to comply. I mean,
right.
You can't, was it Louisville? That's got a bunch of restaurants who have signed on together to basically say, we're all going to stay open. They made a pact.
Good.
And
if you don't want to go, don't go. That's what gets me about all these holier than thou intellectuals. Like, don't go. Your problem is solved.
Yeah, exactly. Stay home. You're worried. Right. You stay home. But
right.
They're going to use the argument of it's for everyone's good. I worry about me. You worry about you. How about we do that?
Right. Exactly.
Anyway.
Yeah.
All right. So do you think that this is a good bellwether of where we're going future-wise for cases from basically lockdown cases and this sort of thing that we're going to, I'm sure, see more of as this thing keeps going and going?
I think you will see more protection of religions because of the change of the Supreme Court. I mean, remember, Roberts was a Republican nominee, and he was on the other side of this one as well. It was the RBG replacement, ACB, that really made the difference here. Yeah. Was the number-wise, just by voting. So I think you will see more of that, and we'll see how that plays out. And I'm in favor of free association, right?
Yeah. Same
if
here.
somebody doesn't want to bake you a cake, don't give them your money. This isn't a time where you couldn't get a cake, or like in the heart of Atlanta motel, where the Supreme Court first applied the Commerce Clause to something that was purely an intrastate activity, because they didn't want. I mean, the heart of Atlanta motel was racist. The owner was racist, right? And they wanted to stop that, and so they said federal government had authority to do it. I mean, that's not going to change, but I think a lot of the applications of it that have gone even beyond that are attempts to apply the Commerce Clause and other usurpations of state sovereignty to the federal government. I think you'll see less of that. So, like in this case.
Well, it'll be an interesting next year with Biden in, and he's wants to lock everybody down tight, and
yeah.
So he's going to be supportive of those governors who are trying to do it. So it's going to be an interesting dynamic next year going forward.
Yeah, absolutely. And there's a lot more issues involved in this, a lot more details. Mm-hmm. So read the case. I always recommend that. On all my podcasts, I put a link to the actual case where you can read it yourself. And I go into a little bit more of some of the nuances of it soon. It will be out soon. So
did you record an episode on this then?
I'm about to. I've got the outline. And so it's on Twitter at the law DKW. When it's out, you'll see it there.
Awesome.
Cool.
All right. Well, thank you, DK.
Always a pleasure.
Checking in with you again as more cases come up, especially ones like this.
Awesome.
Thank you all listeners for listening to Annette on Life, Liberty, and Happiness, where freedom lovers gather. You can find me on AnnetteTalks.com, iTunes, Stitcher, Spotify, YouTube.com/Annette Talks, Amazon Music, there we go. Thank you. That's the law with DK Williams right there on his notebook for those of you watching YouTube. If you're just listening, go to YouTube.com/Annette Talks and you can see what we look like.
You can see what Annette looks like. You can see me too, but you'd much rather see her.
You could see both of us. We're both single, by the way. All right. Well, thank you again for listening, and we'll talk to you later.